They call. Unknown number. You see it flash on your screen and your stomach drops. You let it go to voicemail. You know what it is before you even listen. They text. Messages that sound official, urgent, threatening. Your account has been placed with our agency for collection. Immediate action required. Contact us within 24 hours to avoid further escalation. They leave voicemails. The tone is formal, almost mechanical, but underneath is pressure, implication, threat. This is an attempt to collect a debt. Failure to respond may result in legal action. You feel your chest tighten. Your heart races. You freeze. You don't know what's real and what's just pressure tactics. You don't know if ignoring them makes it worse. You don't know if talking to them makes it worse. You're paralyzed by uncertainty and fear. But before you panic, this video will show you exactly how to stop the calls, use your rights, and take back control. So stop, breathe, and understand this. You have rights. Specific, enforceable, federal rights that protect you from harassment and abuse and deception. And most of the power debt collectors have over you comes from one thing: your fear, your uncertainty, your belief that they can do things they actually can't, your assumption that you're helpless and they're in control. That's not true. But they need you to believe it is. If you've ever had a debt collector call and felt your heart drop, if you've ever seen an unknown number and felt panic before you even answered, comment yes, because you're not alone. Millions of people are living that same moment right now, and most of them don't know that the fear is the weapon, not the debt itself. This is educational content, not legal, financial, or debt relief advice. Debt collection laws vary by state and situation. Always verify your specific circumstances with a qualified attorney or legitimate credit counselor before taking action. The debt collection industry in America is worth over $13 billion annually. That's not $13 billion in debts being repaid to original creditors helping people resolve legitimate obligations. That's $13 billion in revenue for collection agencies, companies whose entire business model is buying debts for pennies and collecting dollars. Not because everyone can pay, not because every debt is valid, not because the system is fair, because fear works, because pressure works, because most people don't know their rights and panic when they're threatened. They profit when you panic. When you agree to payment plans you can't afford just to make the calls stop. When you pay debts that might be past the statute of limitations or that you might not even legally owe. When you believe every threat and every deadline and every implication of consequences. That's the business model. Not justice, not helping people resolve legitimate debts. Fear-based extraction from people who don't know they have power to push back. Here's what they don't tell you when they call, what they hope you never learn. What would undermine their entire approach if everyone understood it? First, debt collectors aren't the original lenders. In most cases, they're not working for the company you originally owed money to. They're third parties who bought your debt, often for a fraction of what you owed, and are now trying to collect the full amount plus fees and interest. If you owed $1,000 on a credit card and defaulted, the credit card company might sell that debt to a collection agency for $50 or $100. Maybe less. The debt gets bundled with thousands of other debts and sold in portfolios for pennies on the dollar. Now the collection agency owns that debt. They paid $50 for it. Every dollar they collect from you is profit. If they can get you to pay $500 through pressure and fear, they've made 10 times what they paid. If they get the full $1,000 plus fees, they've made 20 times their investment. That's why they're so aggressive. That's why they use fear tactics. That's why they call repeatedly and threaten legal action. Because the math works heavily in their favor, and the only thing stopping them from massive profit is you understanding that you have leverage. Second, you have the right to validation under federal law. Your right to validation, FDCPA. Within 5 days of first contacting you, a collector must send a written notice. From the day you receive that notice, you have 30 days to dispute the debt in writing and request validation. If you dispute within 30 days, they must pause collection until they mail proper validation. If you dispute after 30 days, they may continue, but they still can't mislead you and must fix errors. That validation must include the amount, original creditor, itemization, and evidence they own or are authorized to collect the debt. When you dispute within 30 days, they can't report the debt to credit bureaus without flagging it as disputed, and they must update any existing report. Your state may require collection agencies to be registered or licensed. Check your state database to verify their status. And here's the thing. Many collection agencies can't provide complete documentation. They bought the debt in a bulk portfolio with minimal paperwork. They might have a spreadsheet with your name and a number, but they don't have the original contract or detailed account history or proof that you actually owe what they claim. So they rely on you not asking. They rely on you just accepting their word. They rely on you panicking and paying before you think to demand proof. Third, they can't threaten or harass you. Federal law, the FDCPA, strictly limits what debt collectors can do. They can't call you before 8 a.m. or after 9 p.m. in your time zone. Call you at work if you've told them your employer doesn't allow it. Harass you with repeated calls designed to annoy or abuse. Threaten violence or harm. Threaten arrest. Debt is a civil matter, not criminal, and you can't be arrested for owing money. Use obscene or profane language. Falsely claim to be attorneys or law enforcement or government officials. Lie about the amount you owe or the consequences of not paying. Threaten to seize property or garnish wages unless they actually have legal authority to do so. Garnishment requires a judgment, usually. For most consumer debts, wages or bank accounts can't be seized without a court judgment. Exceptions. Some federal student loans and tax debts can be garnished administratively without going to court. Don't let a collector imply they can garnish today without due process. Call frequency. CFPB Reg EF. More than 7 attempts in 7 days per debt, or any call within 7 days after a conversation, is presumed harassment. Document it. Every one of these violations is illegal. But they still happen. Constantly. Because collectors know most people don't know the law. Most people don't know what's legal threat versus illegal harassment. So when a collector says, "We're sending the sheriff to your house tomorrow," or "You'll be arrested if you don't pay immediately," those are lies. Illegal lies. And if you document them, you can report the collector and potentially sue them for violating your rights. Remember, they rely on fear and silence. Once you understand the law, you're harder to scare. But here's the part the industry relies on most. Most people don't know their rights. Most people have never heard of the Fair Debt Collection Practices Act. Most people don't know they can demand validation, or that threats of arrest are illegal, or that they can stop the calls with a simple written request. They hear, "We're taking you to court," and panic. They hear, "Your wages will be garnished," and start paying whatever they can scrape together just to make it stop. They hear, "This is your final notice," and believe it, even though they've gotten 5 final notices already. That fear, that uncertainty, that panic, that's the product. That's what they're selling. The actual debt is secondary to the fear that makes you pay without questioning whether you legally have to. The truth is, debt collectors don't want to go to court. Litigation is expensive. It's time-consuming. It requires documentation they often don't have. It risks you showing up with a lawyer who exposes that they can't prove the debt, or that the statute of limitations has expired, or that they violated collection laws. Going to court is the last thing most collectors want. They just need you to believe they're ready and willing to do it. They need you to believe the threat so you pay before it gets that far. Most collection calls are bluffs. Most threats are pressure tactics. Most final notices aren't final. Most legal action warnings never materialize. They're counting on fear doing the work for them. On you not calling their bluff. On you not knowing that you have power in this situation. So here's how you fight back. Not with anger, not with avoidance, but calmly, systematically, using the law that exists specifically to protect you from abusive collection practices. This is information about your rights, not legal advice. Every situation is different. Debt laws vary by state. Consult a qualified attorney or legitimate nonprofit credit counselor for guidance on your specific situation. But here's what you need to understand. Step 1. Never agree to anything over the phone, ever. Collectors are trained to get you to acknowledge the debt, to agree to payment, to commit to terms while you're off balance and scared. The moment you say, "Yes, I owe this," or "I'll pay $50 a month," or "I can send something next week," you've potentially reset statutes of limitations, created new agreements, admitted liability. Don't do it. No matter how much they pressure you, no matter how urgent they make it sound, no matter what they promise or threaten. Phone script. I won't discuss this by phone. Please mail me the written notice. Do not call me again. All future communication must be in writing. Cease communication. Letter. Send a short letter by certified mail stating you demand all communication stop. After they receive it, they may only contact you to confirm they'll stop or to give specific legal notice. For example, that they're filing a lawsuit. If your employer doesn't allow personal calls, tell the collector in writing, calls to your workplace must stop. If certain hours or places are inconvenient, say so in writing. Them calling then violates the law. Some text or email contacts require your prior consent or specific disclosures. If you didn't consent, say so in writing. Recording calls, laws vary by state. Some allow one-party consent, others require both parties to agree. Check your state's law before recording. Then you hang up. That's it. You don't explain, you don't justify, you don't provide information. You state your position and end the call. Step 2. Send a written request for debt validation within 30 days of receiving their initial notice. You have 30 days from when you receive their written notice to dispute and request validation. Do it. In writing. Certified mail with return receipt so you have proof. Your letter should be simple and direct. I am disputing this debt and requesting validation under the Fair Debt Collection Practices Act. You must provide verification of the debt amount, name of the original creditor, itemization of charges, proof that you are licensed to collect in my state, and documentation showing you own this debt or are authorized to collect it. Until you provide complete validation, you must cease all collection activities. All future communication must be in writing to this address. Sign it, date it, keep a copy, send it certified mail. Once they receive it, they must stop collection efforts until they provide validation. If they continue calling or sending demands without validating, they're violating federal law. Step 3. Keep meticulous records of everything. Every call, every text, every voicemail, every letter. Document dates, times, names of collectors you spoke to, exactly what was said, any threats made, any violations of law. Use a simple spreadsheet or notes app. Same format every time. Date, time, number, name, summary, violation. Use a notebook or spreadsheet. Record the date and time of each contact. If they call and you answer, immediately write down date, time, collector's name, company name, what they said, what you said. If they threaten arrest or claim to be law enforcement or call outside allowed hours or call more than 7 times in 7 days, document it. This documentation is your evidence if you need to file complaints or defend yourself or potentially sue them for violations. Without records, it's your word against theirs. With detailed records, you have proof. Step 4. Understand the statute of limitations for debt in your state. Time-barred debt. Each state sets a statute of limitations, often 3 to 6 years, sometimes longer. If a debt is time-barred, a collector can't sue lawfully in many states. In others, they might still file, and your defense is to raise the statute of limitations in court. Never acknowledge the debt or make a partial payment until you know the status. Doing so can restart the clock in some states. Some states require collectors to tell you when a debt is time-barred. Missing that disclosure can be its own violation. If a collector contacts you about a debt that's 6 or 8 or 10 years old, it may be past the statute of limitations. If so, you can send a letter stating, "This debt appears to be time-barred under your state law. If you cannot sue to collect it, cease all collection activities." But be extremely careful. The rules vary by state. In some states, even a small payment or written acknowledgement can restart the limitations period. That's why you never acknowledge or promise payment over the phone without first understanding your situation fully. Step 5. If they violate your rights, report them and consider legal action. If a collector harasses you, threatens you illegally, continues calling after you've told them to stop, contacts you outside allowed hours, lies about the debt or the consequences, they violated the FDCPA. You can report them to the Consumer Financial Protection Bureau, CFPB, at consumerfinance.gov/complaint. Your state attorney general's office, the Federal Trade Commission, and you can sue them. The FDCPA allows you to sue collectors who violate the law and recover damages up to $1,000 plus actual damages, attorney fees, and costs. Many consumer rights attorneys work on contingency, meaning they only get paid if you win. If you have documented violations, you have a case. Collectors rely on you not knowing this. They violate the law constantly because the risk is low. Most people don't report or sue, but when people do, it works. Collectors settle quickly because they don't want their practices exposed in court. Step 6. Understand the difference between debt collectors and original creditors. The FDCPA applies to third-party debt collectors, not to the original creditor. So if your credit card company is trying to collect a debt you owe them directly, the FDCPA doesn't apply. But many states have their own consumer protection laws that do. Once your debt is sold to a third party or sent to a collection agency, then the FDCPA applies fully. Know who you're dealing with. If it's a third-party collector, your rights under the FDCPA are clear and strong. Step 7. Consider negotiating, but only in writing and only after validation. If the debt is legitimate and you want to resolve it, you can negotiate. Collectors will often settle for less than the full amount, sometimes significantly less, because they bought the debt cheap and any payment is profit. But negotiate only after they validated the debt, only in writing, only with clear terms. Get any settlement agreement in writing before you pay $1. Paid in full or settled in full for X dollars must be in writing before payment. No letter, no money. Make sure it states the amount you're paying, that this payment resolves the debt in full, that they will report the debt as settled to credit bureaus, and that they will not sell or transfer any remaining balance. Tax note, 1099 to C. If $600 or more is forgiven, you may receive a 1099-C form. Canceled debt can be taxable income. The insolvency exclusion may reduce or erase the tax burden. Talk to a tax professional about Form 982. Without written agreement, they can take your payment and still claim you owe more, or sell the remaining balance to another collector who starts the process over. Protect yourself with documentation. Drop a yes in the comments if this information makes you feel more in control, because that's the moment people stop being victims and start taking their power back. Let's talk about what debt collectors do to manipulate you. The psychological tactics, the pressure techniques, the ways they're trained to get you to pay without thinking. They create artificial urgency. This is your final notice. You must respond within 24 hours. We're filing legal action tomorrow unless we hear from you today. All designed to make you panic and pay immediately without asking questions. Most of it is fake. There's no actual deadline, no lawsuit being filed tomorrow, no final notice that's actually final. It's pressure designed to override your rational thinking. They imply consequences they can't deliver. Your credit will be destroyed. You'll never get a loan again. We'll garnish your wages. We'll take your house. Most of these are exaggerations or outright lies. They can't garnish wages or seize property without a court judgment, which requires suing you first and winning. They can't destroy credit beyond what the debt already did. They use guilt and shame. Don't you want to pay what you owe? You're a responsible person, right? Think about your family. They're trained to make you feel morally obligated, to appeal to your sense of responsibility, to make non-payment feel like a character flaw. But here's the thing. Debt is a financial contract, not a moral obligation. You may have circumstances that made payment impossible: job loss, medical emergency, divorce, unexpected expenses. That doesn't make you a bad person. It makes you a human facing difficult circumstances. And if the debt is past the statute of limitations, or if the collector can't validate it, or if they violated the law in collecting it, you don't owe it, legally or morally. They pretend to be your friend. I want to help you. Let's work together to figure this out. I'm on your side here. This is a tactic called false empathy. They're not your friend. They're not on your side. They're trying to get you to trust them so you'll agree to things you shouldn't. Don't fall for it. Be polite, but firm. You're not having a friendly conversation. You're engaging in a legal and financial matter where your interests and theirs are opposite. They use confusion and complexity. They throw around legal-sounding terms. They reference laws and procedures you've never heard of. They make it sound like the situation is complicated, and you need their guidance to navigate it. The truth is usually simpler than they make it sound. You either owe the debt or you don't. Either it's within the statute of limitations or it isn't. Either they can prove it or they can't. Don't let complexity intimidate you into paying without understanding. Let's talk about what happens if they do sue you. Because that's the ultimate fear, right? That you'll be taken to court, that you'll have a judgment against you, that your wages will be garnished or your bank account seized. It can happen. If you legitimately owe a debt and it's within the statute of limitations and the collector has proper documentation, they can sue you. And if you don't respond to the lawsuit, they can win by default and get a judgment. But here's what most people don't know. Most collectors win lawsuits not because they're right, but because the defendant never shows up. Always respond to any lawsuit. Ignoring it is the worst thing you can do. If you're sued, don't ignore it. Don't assume you'll automatically lose. Respond to the lawsuit. Show up to court. You can represent yourself, or you can seek help from a legal aid organization or a consumer rights attorney. Common defenses in collection lawsuits. The debt is past the statute of limitations. The collector can't prove you owe the debt or can't prove the amount. The collector doesn't have standing to sue because they can't prove they own the debt. You already paid the debt or settled it. The debt isn't yours, it's someone else's, or it's fraudulent. The collector violated the FDCPA during collection, which may limit or eliminate their ability to collect. Many collection lawsuits are filed with minimal documentation. The collector files a complaint, hopes you don't respond, wins a default judgment, and moves to garnish wages or bank accounts. But if you show up and demand proof, many cases fall apart because the collector can't actually prove their case with admissible evidence. If you get sued, don't panic. Read the complaint carefully. Note the deadline to respond, usually 20 to 30 days. File an answer denying the claims and asserting defenses. Request documentation proving the debt in discovery. Show up to court. Bring any documentation you have that supports your defense. If you can't afford an attorney, look for legal aid organizations in your area. Many provide free or low-cost help with debt collection cases. Some consumer rights attorneys take these cases on contingency. You have options. And remember, even if you lose the lawsuit and a judgment is entered against you, bankruptcy remains an option if your financial situation is truly unmanageable. Judgments can often be discharged in bankruptcy. It's not ideal, but it's not the end of the world either. Now let's talk about the emotional toll. Because debt collection isn't just a financial problem. It's a psychological one. The constant stress, the fear, the shame, the feeling of being chased, the dread every time your phone rings. That's real. That's not weakness. That's not overreacting. That's the intended effect of an industry designed to use fear as leverage. Debt collectors are trained to make you uncomfortable, to keep you off balance, to maintain pressure until you pay. The psychological impact is part of the business model, but you can protect your mental health while dealing with this. Set boundaries with collectors immediately. Tell them in writing to stop calling and communicate only by mail. Block their numbers if they violate that request. Check your voicemail once a day at a specific time instead of living in fear of calls. Set a 15-minute debt hour once a week. Do only one action. Send a letter, log calls, check a deadline. Control beats panic. Separate your worth from your debt. You are not your financial situation. A past due bill doesn't define your character or your value as a person. Economic hardship happens to millions of people through no fault of their own. It doesn't make you a failure. Talk about it. The shame and secrecy around debt are part of what gives collectors power. Talk to trusted friends or family. Seek support from online communities of people dealing with similar issues. Consider therapy if the stress is overwhelming. Take action instead of avoiding. Avoidance makes the anxiety worse. It doesn't make the debt go away, but it gives collectors more leverage. Taking action, even small steps like requesting validation or documenting calls, gives you back some control and reduces the feeling of helplessness. Understand that this is temporary. Debt situations feel permanent when you're in them, but they're not. Debts get resolved through payment or settlement or statute of limitations or bankruptcy. The calls don't last forever. The situation will change. You will get through this, and know that you're not alone. Over 70 million Americans have debts in collections. That's not 70 million irresponsible people. That's 70 million people who faced circumstances, medical emergencies, job loss, divorce, unexpected expenses that made paying impossible or delayed. You're part of a massive group of people navigating the same system, the same pressure, the same fear. And when you understand your rights and use them, you're not just helping yourself, you're chipping away at the power of an industry that depends on people not knowing they have leverage. Here's what you need to understand about the bigger picture. The debt collection system is designed to transfer as much money as possible from people with the least power to companies with the most. Collectors buy debts for pennies, then use fear and pressure and legal-sounding threats to extract dollars. They rely on information asymmetry. They know the law, you don't. They know their rights and your rights, you only know fear. They profit from confusion and panic. From people paying debts that are past the statute of limitations. From people paying debts they don't actually owe. From people agreeing to payment plans they can't afford just to stop the harassment. The system isn't designed to help you resolve legitimate debts fairly. It's designed to extract maximum money through minimum effort, using psychological pressure instead of legal merit. But the system only works when you don't know your rights, when you don't demand validation, when you don't document violations, when you don't push back. Every time you request validation in writing, you force them to do work. Every time you document a violation and report it, you create risk for them. Every time you refuse to pay an invalid or time-barred debt, you cut into their profit margin. You have power. You're not helpless. You're protected by federal law and often by state law. You can make collectors prove their case. You can stop the harassment. You can fight back legally without breaking any laws yourself. The debt collection industry depends on you not knowing this, on you being too scared or too ashamed or too overwhelmed to learn your rights and use them. But now you know. Now you understand that the fear is the weapon, not the debt. Now you can respond strategically instead of emotionally. Let's be clear about something. This isn't about encouraging people not to pay legitimate debts. If you owe money, if you can afford to pay it, If the debt is valid and properly documented, paying it is reasonable and often the best path forward. But legitimate debt and debt that a collector claims you owe aren't always the same thing. And can't afford to pay is a real constraint that collectors pretend doesn't exist. You have the right to verify that the debt is actually yours. Verify the amount is correct. Verify that the collector has legal standing to collect. Verify that the debt is within the statute of limitations. Negotiate payment terms that don't destroy your ability to survive financially. None of those rights are about dodging responsibility. They're about ensuring that what you're being asked to pay is actually owed, that the entity asking has the right to collect, and that you're protected from abuse and deception. Using your rights doesn't make you a deadbeat. It makes you an informed consumer, protecting yourself from an industry that routinely violates the law and uses fear to extract money that often isn't legally collectible. Here are some final practical points that didn't fit neatly elsewhere, but are important to know. Never give collectors access to your bank account. They'll ask for authorization to debit your account automatically. Don't do it. Once they have access, they can take more than agreed or take money when you can't afford it. Always pay by method you control. Check. Money order, debit card for single transaction. Be careful about re-aging debt. Making a payment or acknowledging the debt can restart the statute of limitations in some states. Before you pay anything, understand whether the debt is time-barred and what impact payment would have. Understand pay for delete. Some collectors will agree to remove the collection from your credit report if you pay. This isn't guaranteed and isn't technically allowed under credit reporting rules, but it happens. Get any such agreement in writing before paying. Know that paid collections still appear on your credit report. Paying a collection changes it from unpaid to paid, but it doesn't remove it. Only time, 7 years from first delinquency, or negotiated removal does that. Beware of debt settlement companies. Many charge high fees to do things you can do yourself for free. Some are outright scams. If you want to settle, negotiate directly with collectors in writing or work with a legitimate nonprofit credit counseling agency. Check your credit report regularly. You're entitled to a free report from each of the 3 bureaus once a year at annualcreditreport.com. Check for inaccuracies, debts that aren't yours, debts past the reporting period. Dispute errors in writing. Consider bankruptcy if debt is truly overwhelming. It's not a moral failure. It's a legal tool designed to give people a fresh start. If you have multiple debts, no realistic way to pay them, collectors threatening legal action, talk to a bankruptcy attorney. Many offer free consultations. You can't control that collectors will call. You can't stop companies from selling your debt. You can't make past financial problems disappear instantly. But you can control how you respond. You can stop the panic. You can learn your rights and use them. You can document violations and report them. You can demand proof before paying. You can negotiate from a position of knowledge instead of fear. The debt collection industry uses fear as leverage. You use knowledge as defense. They try to overwhelm you with urgency and threats. You respond with calm, systematic use of the law. They hope you'll panic and pay without asking questions. You demand validation and documentation. They violate the law constantly because they think you won't notice or won't do anything about it. You document violations and report them and consider legal action. That's how you take power back. Not through avoiding or ignoring, through understanding and action. Drop your experience in the comments. Have you dealt with debt collectors? What tactics did they use? What worked for you in pushing back? What do you wish you'd known earlier? Because the more people share their experiences openly, the more others learn. The more the industry's tactics become public knowledge. The more people understand they have rights and power. The debt collection system depends on silence and shame and isolation. It depends on each person thinking they're the only one struggling, that they're uniquely failing, that they have no options. But when millions of people start comparing notes, sharing strategies, teaching each other the law, the system loses its primary weapon. Fear stops working when everyone knows it's mostly bluff. They want you to panic. They want you to believe you're powerless. They want you to pay immediately without thinking or questioning or demanding proof. But you're not powerless. You're protected by law. You have rights. You have leverage. You have the ability to demand validation, to stop harassment, to negotiate from knowledge, to report violations, to fight back legally. The collection call that makes your heart race, that's designed. The voicemail that sounds urgent and threatening, that's tactic. The letter that implies immediate legal action, that's usually bluff. Understanding that changes everything. It doesn't make the debt disappear, but it makes you the one in control of the conversation instead of them. Because the trap only works when you don't see it. When you believe their urgency. When you accept their power as absolute. When you think you have no choice but to comply. Now you see it. Now you understand the tactics. Now you know your rights. And knowing your rights is the first step to using them, to protecting yourself, to stopping the fear from doing their work for them. They use fear. You use knowledge. And once you do, they lose their only weapon.